Melville ma dellusiwaat ci yow rek ak beneen correction ba tey si lu jëmaat ci this legal battle laaj bi mooy Melville bi nga gisee ñaari lettres yëpp somebody koo xam ne sa xel màcc na ci wàllu yoon xam nga ko bi nga xoolee ñaari lettres yëpp te ñu gis ne ñoom ñaar ñëpp wala ku ci nekk sa lawyer yi dañ pare nañ bu fekkee ne li ñuy sàkku amul ñu dem ak yow ci yoon. ndax tey yow boo doon advice kenn ci ñoom ñaar pour ñu dem ndax foog nga ne kan nga doon wax ne kii bu demee mun na fa am jafe-jafe ci ñoom ñaar ñëpp muy Bensouda wala muy Kurang because am na ñuy wax ne ami Bensouda kenn ñemewu koo challenge ci fi nga xam ne mooy ci attekaay yi ndax am na ko fi defoon dafa mujjee jéggalu ak ñeneen ñoo xam ne defoon nañ ko fi bi mu leen traité ne dañ mujjee jéggalu boo Kurang dafa mel ni dafa xaw a wuti ak ñooñ ndax moom tontu na wax ko ne ko moom pare na. tey yow nan nga ko gisee ginnaaw gis nga ñaari lettres yëpp ndax foog nga ne yow boo doon advice kenn legally kan nga doon wax ne na toog wala na jéem a fexe ñu settle ko out of court.
Okay. So first, I can't speak Mandinka, but I think the gentleman, the previous panelist,
Mr. Damfa,
he mentioned something about, no. I think it's the professor. I think he's the lecturer at the university. I'm not too sure. He mentioned something about, about people should bring, they should try to get them to sort this matter out, and, it should be like everybody should, talk about it. It should be a national concern. Am I right? Is that what he said?
Yes,
I just want to be clear before I make a comment.
That is right.
Okay. So the first thing we need to clarify, and I think this is the issue that we're having with this Alhaji Kurang case. And you see, I think the timing of the cease and desist letter is what has fundamentally changed the conversation. So people need to understand that Ami Bensouda is a Gambian, a normal private person, regardless of her years of legal expertise. She is an individual Gambian, a lone Gambian. Mamadi Kurang, regardless of his contributions to governance and teaching and everything, his expertise and all of that, he is a lone Gambian. He is an individual. This cease and desist letter and counterclaim is between two private individuals. There is nothing that warrants a national concern. If you do it for Bensouda and Kurang, you would have to do it for Melville and Dudu. You will have to do it for Modu and Lamin. What is there between Ami Bensouda and Kurang that should require a national discourse to an extent that people should try to speak to them? No, they can advise themselves legally. Ami Bensouda is a bona fide lawyer with years of expertise and practice. Kurang has got phenomenal lawyers that are representing him. Both of them know the facts. Both of them know the evidences that they have. They need to advise themselves. There is nothing whatsoever that warrants a national conversation. The only reason why we are speaking about Kurang and Bensouda with regards to a legal suit is because it's got a public interest dimension. Because the allegations stem from the Janneh Commission. And because the allegations stem from the Janneh Commission, and the issue of the Janneh Commission is a subject of public interest, subsequent to the damning report that came from the Republic, which was done by Mustafa Dabo, so it became a national interest. So the subject matter in itself is that of concern to the average Gambian. But when it comes to the suit, when it comes to the threatening of a legal action between the parties, it's got nothing to do with Gambians. That is between two individuals. And I keep saying, if Kurang and Ami Bensouda goes to court, it will be between Kurang and Ami Bensouda. What will be in that court is the allegation of defamation that Ami Bensouda is alleging that Kurang has made against her. That is the only thing that will be tested. In that court of law, it would not be about the Janneh Commission. Okay. It would not be about the disposal of assets. What would be tested is what Kurang has said, the remarks that Kurang has been making for the past 7 years. The court will test the veracity of that. They will check to see whether it is factual. They will check to see whether what Ami Bensouda is claiming that it has harmed her reputation, it has damaged her character, is factual. And that is what the court is going to adjudicate upon. It will not give Gambians the answers to the Janneh Commission. It will not give Gambians answers to how the commission was run. The court will not look at the activities of the commission. The court will look at the case between Kurang and Ami Bensouda with regards to defamatory remarks. That is the absolute truth. Now, going to your question to look at the letters.
Yes.
Now, a fundamental issue that I saw in the letter of Kurang, and I will draw your attention so that your panelists can make a comparative analysis, is that I tried to explain earlier the reason why people will not just get up and go to court, but people will decide to send a cease and desist letter, which is called a pre-action protocol. Why would you send a pre-action protocol? The reason why you send a pre-action protocol is to show that you have tried to avoid going to court, and you're only going to court as a last resort. So your pre-action protocol has to show a level of reasonableness with regards to your asking and your demands and the conditions that you lay down. Now, for example, when Ami Bensouda laid her condition, she said, apologize to me, stop talking about me, retract your statements, and that's it. That's all she asked for, that's it. If you don't do that, then I will go to court. Now, let's look at Kurang's letter. Kurang is saying, apologize, retract your statement, stop talking about me, and give me 200 million. That is a fundamental flaw legally in that letter. And the reason why it's a fundamental flaw is because it is not Ami Bensouda or Kurang that can determine the amount of damage done to them or what can be the compensation. It is only the courts. The reason why you are taking a defamation case to court and asking for damages is because it is only the court that is vested with the authority and power to quantify the damage. So Mrs. Bensouda did not ask Kurang for 144 million. Mrs. Bensouda is saying, if you don't apologize, then I will go to court and I will ask the court for damages of up to 144 million. But Kurang, on the other hand, is saying, give me 200 million. We all know, I mean, we are all rational thinking people. You know that is impossible. I mean, Bensouda is not going to take $200 million and give it to Kurang. That's over $2 million. That is not reasonable. That is what the court is going to look at. And the court is going to ask themselves, did Kurang really want to sort this matter? What was the need for that pre-action protocol? The pre-action protocol, is this a way that you want to avoid the court? Because Ami Bensouda is just saying apologize. Say sorry to me. Stop what you're saying. And that's it. If Kurang did that, there's no 144 million. But Kurang is telling you that you have to apologize, you have to say sorry, you have to give me 200 million. If you don't give me, then I will go to court. So you see the distinction in that legality. Now, if Mrs. Bensouda asks for 144 million, it does not mean that the court is going to give her 244 million. The court is going to check whether the damage, the harm done, corresponds with the allegation of defamation. That is how compensation is quantified in court. They would look at it. For example, Mrs. Bensouda is saying Kurang has been disparaging her for 7 years. Kurang is only saying that Mrs. Bensouda has disparaged her in the letter that was written to Kurang. Now, how long has that letter been in the public space? 7 days.
Ndax letter bob sorry
disparaging me.
Sorry Melville, ndax letter bob tamit comme jàpp ne comme it's a classified document la war to génn ak yu mel noonu wala yow legally letter bob
I will come to that. I will come to that.
Very good.
So basically, when the courts look at these things, this is what they will look at. How did Kurang arrive at 144 million? One legal principle that was established in defamation cases is that defamation case is not there to enrich the parties. It is there to cure a harm. So if there was damage done, so for example, Kurang would have to show that what Mrs. Bensouda said in that letter spoiled his business, made him not to get jobs. You have to show, you have to draw a correlation. You have to draw the nexus between the harm and the damage. That is what the courts look at. But it is only the court that can determine that, nobody else. So I did not understand why the lawyers of Kurang would just get up and ask for 200 million. How long has that defamation been going on that Ami Bensouda said? What is the defamation? I expected that Kurang had a brilliant opportunity in his rebuttal to raise defamation. But what Kurang raised in the defamation, so for example, saying, you have insulted me, you have called me a liar, you have said I'm a thief, that is not true. The letter that Mrs. Bensouda sent did not say that. The letter that Mrs. Bensouda sent stated what is in the public record. And everybody, even if you hate, and one thing I wanted to say before I continue, I am not saying Kurang is guilty. I am not saying Kurang is right. I'm not saying Mrs. Bensouda is guilty. I'm not saying Mrs. Bensouda is right. If people have been following me, they would know that I stick to the facts. I am only analyzing the letters. I am only analyzing the factual reasoning and the legal attachment to these letters.
Okay.
And that is what I'm dealing with squarely. Now, when Kurang, you would have expected, like Mrs. Bensouda did, Mrs. Bensouda enumerated the things that Kurang have said. She gave examples to Kurang's pronouncements, Kurang's post. But this letter, like you said, is a privileged communication that was written by Mrs. Bensouda's lawyers. She received instruction. She gave instruction to her lawyers. And her lawyers are saying that this is what is held in the public record. Can somebody in your panel show me one thing that Mrs. Bensouda has said in that letter that came from Mrs. Bensouda herself, that Kurang, you're a liar, Kurang, you're a thief? It is not there.
Correct.
It is not there.
Okay. All right, Melville. Still now, because first part of Subi, demal batay. But
no, let me just. You asked a very important question.
Very good. Yeah. No
and
problem.
also,
go on.
Pardon me.
All right. Okay. Go on.
Yes, the most important. So if you look at Kurang's counterclaim, one of the ingredients of defamation, which I mentioned to you, is to show that the defamatory remarks are made to a third party or brought to the attention of a third party. Now, a letter that was written to Kurang by Mrs. Bensouda's lawyers, Kurang would have to demonstrate to the court absolutely and squarely that it was Mrs. Bensouda that leaked that letter into the press. He would have to show and lead evidence that it is Mrs. Bensouda's lawyers that leaked that letter to the press. But the pronouncements of Kurang, Mrs. Bensouda does not have to demonstrate or show that Kurang made that to a third party because Kurang made it. These are on Kurang's Facebook post. These are on Kurang's interviews. How would Kurang prove that a letter written by Ami Bensouda's lawyers addressed to Kurang, I'm sure a hard copy was given to him, was leaked online by Mrs. Bensouda? Because that is a fundamental ingredient to prove that it was Mrs. Bensouda that brought it to the attention of the third person, of the public. Okay. How would Kurang prove that? How are you sure that it is not Kurang that sent the letter to somebody he trusts, who sent it to someone else, and the letter ended up in social media? How are you sure that it is not Kurang, because knowing of the public interest that is in this matter, decided to put it out for public sympathy? We don't know. I'm not saying that's what he did. I'm just telling you what the courts will look at, how the courts would think, how the courts would reason. But let us look at something very important again in Kurang's letter, which I think his lawyers completely missed the ball on that. Because when Mrs. Bensouda mentioned the things that Kurang have said, Kurang did not deny saying it. I expected that Kurang would have, in that letter, say instantly that I did not say it. But Kurang did not say that. Kurang said, I did not refer to you. He said, your client has misconstrued. What that word means, to misconstrue, is for your client to take what I am saying about somebody else to attribute it to you. So if you look at that letter, Kurang did not deny. He is admitting that, yes, I made the statement, but I made the statements against the Janneh Commission. That's what he said. He said the comments were made directed to the commission, but your client misconstrued it and accepted it as if I was referring to her. But we all know that Kurang did not refer to the commission. Kurang repeatedly and consistently and constantly referred to Ami Bensouda. So now, another level of work that Kurang has, which by the letter that the lawyers have done for him, they have given him more work, because Kurang would have to prove to the court that when he said, for example, when he said, go and ask Ami Bensouda, that he was referring to the commission and not Ami Bensouda.
Okay.